Mr. Speaker, further anticipating the consequences of this bill, if it were to be adopted, we can expect it to have a disparate impact on Canadians based on their province or territory of residence. Much was made during committee of the particulars of the provincial fine option programs, to which I referred briefly earlier in my remarks. Regrettably, Mr. Speaker, the discussion during committee regarding these programs was particularly insufficient and demonstrated a complete lack of understanding by the government in this particular matter. The government has defended the removal of judicial discretion to waive the surcharge by arguing that those who are not able to pay can take advantage of provincial fine option programs that allow for the disposal of an individual's surcharge obligations through work or community service. However, as I am sure the members in this place are by now well aware, such programs do not exist at all in Ontario, in British Columbia, or Newfoundland and Labrador. Moreover, where they do exist, their availability and eligibility themselves vary drastically. I would hope that my colleagues in this place would need no explanation as to why I object to legislation that affects Canadians in a discriminatory manner based on where they happen to reside without any reasonable justification. What is particularly troubling, however, was the lack of concern by some of my colleagues during the committee process in this regard. Indeed, one member, noting that the fine option program is clearly a matter of provincial competency, conceded that this is not something the federal government can delve into, and went on to observe that it is sufficient that any province could use the funds from the surcharge to implement such a program, and that where no such program exists, other means for enforcing the surcharge may exist. Mr. Speaker, this line of reasoning, regrettably, entirely misses the point. It is irresponsible for us to pass legislation based on predictions and presumptions about what could happen. Furthermore, the lack of consistency between the provinces and territories in this regard is precisely what results in a differential, prejudicial impact. Mr. Speaker, the bottom line is that, depending on the specific province or territory, a low-income Canadian who is simply not able to meet its surcharge obligation will find himself disproportionately burdened merely because of his financial status and his area of residence. Ultimately, one may find himself or herself subject to incarceration for circumstances entirely outside his or her control. Mr. Speaker, I submit that this is prejudicial, inequitable, and unacceptable in a free and democratic society. To conclude my remarks, let me summarize the reasons for my opposition to this legislation. First, the arbitrariness of the proposed doubling of the surcharge amount must be rejected. The needs of victims vary substantially, as I mentioned, between the provinces and territories. Second, we must permit judicial discretion and enable judges to consider the specific facts before them, in particular the undue hardship that may result in specific instances on either the offender or in his or her dependents. Third, there are problematic assumptions underlying the government's approach to criminal justice, which considers after-the-fact punitive measures to be an effective means of achieving deterrence, completely ignoring the importance of preventive measures and the need to consider the relationship between various complex social factors insofar as they contribute to both crime and victimization. Indeed, one critical factor that is undeniably related to the problem of crime and recidivism is the cycle of poverty and the marginalization of particular segments of our society. Regrettably, this bill, as it now stands before us, will only exacerbate this problem. Mr. Speaker, I would like to briefly describe the amendments that I offered at committee, all of which were proposed with the intention of achieving the shared goal of providing support for victims of crime in all provinces and territories in an effective, sustainable, and non-discriminatory fashion. Regrettably, all were rejected, but I believe they deserve discussion here, particularly as they may be relevant to our colleagues in the other place during their deliberations in this matter. My first amendment would have restored the undue hardship defence as it currently exists, but would have implemented a requirement that the court record its reasons for waiving the surcharge in writing. This amendment was directly aimed at improving the surcharge's enforcement rate without improperly infringing on the judiciary's authority to consider all the facts before it in a particular instance. My second amendment would have enabled a court in a jurisdiction where no fine option program exists to suspend the requirement to pay the surcharge based on a finding that the immediate enforcement of the surcharge will result in an undue hardship on the offender or his dependents. This amendment, in line with the Supreme Court decision, would have maintained the mandatory nature of the surcharge in all instances and merely would have enabled the court to suspend the requirement to pay. The surcharge obligation would indeed remain in the event that the individual's financial status should change. Moreover, this amendment would have limited the Court's discretion to waive the surcharge to only those jurisdictions where no fine option program is available. My third amendment would have specifically addressed what I submit should be one of the underlying purposes of criminal justice policy, namely to prevent recidivism by achieving the rehabilitation of offenders. This amendment would have provided the Court with authority to waive the surcharge only in those jurisdictions where no fine option program is available, and based on a finding that the requirement to immediately pay would have a negative effect on an individual's rehabilitation. Again, the surcharge obligation would remain should an individual's circumstances change. My final amendment was intended to codify the Supreme Court of Canada's decision in R and Wu so as to ensure that no Canadian will be subject to imprisonment based on an inability to do so. To be clear, this amendment would not have interfered with a court authority to order incarceration as part of an individual's sentence when so warranted by the specific facts of the case. This amendment would have ensured that neither an individual's financial situation nor the unavailability of a fine option program in a particular jurisdiction would result in incarceration. Put simply, this amendment would have avoided the prejudicial effect of Bill C-37 while preserving its underlying purpose. Despite the fact that this principle has been clarified by our Supreme Court, my amendment was voted down. The committee process could have produced a version of this bill that accomplished the government's intention, and what I'm sure is the intention of all members in this place, to ensure the support of victims of crime without prejudicing any Canadians. Regrettably, we are here today to debate the same flawed version of this bill as was sent to committee. Thus, I must oppose the bill as it is currently written and urge all members in this House to do the same. In conclusion, Mr. Speaker, the most effective way to support victims of crime is to propose and promote legislation that prevents victimization in the first place, that seeks to achieve rehabilitation so as to prevent recidivism upon the inevitable return of offenders back into society. Regrettably, we have yet to see justice legislation from this government focusing on prevention, rehabilitation and reintegration, and C-37 will accomplish no such thing. Despite my strong support for legislation that will fund victim services programs, this bill in its current form remains ineffective and will be counterproductive, discriminatory and prejudicial. I therefore will be voting against it. Thank you, Mr. Speaker.
Question.